Hello, friends, and welcome to another WSIB Truth Matters with Joe Machado on this beautiful Tuesday. I'm excited to talk about the second video that is part of the five-part series dealing with the topic of tribunal jurisprudence. That's Workplace Safety and Insurance Appeals Tribunal jurisprudence. I picked five very specific topics and WSIAT decisions that deal with these topics and how they ruled in favor of the appellant, in this case being the injured worker. So these five cases, I thought, give a pretty good understanding or idea of the stark contrast between how the WSIB case manager and appeals resolution officers deal with issues and the Workplace Safety and Insurance Appeals Tribunal and how they adjudicate appeals and the factors that they consider, the law and policy in rendering their decisions. And so I find that tribunal jurisprudence is very helpful. It was very helpful for me, for my firm, for over 30 years. Where we handled obviously numerous of appeals with over 10,000 clients throughout the province. So this is a tool that we used often. And but this is something that you can learn from. And if you have an appeal on the go, or if you're planning on appealing something, these five-part series videos can be very helpful to you. So today, I'm going to talk about approval for medical marijuana. Got a bit tongue-tied there, and how the WSIB denied the worker entitlement for medical marijuana, and the Workplace Safety and Insurance Appeals Tribunal quite appropriately reversed that. So when vice chairs or panels, tribunal panels, are considering making a decision on a particular issue, they oftentimes refer to tribunal jurisprudence to see if other vice chairs had made decisions in these particular subjects, and how they ruled. And in a lot of cases, vice chairs or panels will adopt that line of thinking. So it's always good to be able to do your research, get that information, cross-reference, and then you're good to go. So I'm going to be covering a tribunal decision today. The decision number is 72/20, made on February 20th, 2020. So it is a very relatively recent decision. And I'm going to basically give you a little bit of background on this worker and how he ended up at the tribunal. So he was hired by his employer in construction in 2002, July 2002. And then he suffered a lower back injury in September of that year while lifting a 300-pound pipe with a coworker. The WSIB accepted entitlement in the claim for in the L5-S1 spine area. He was awarded a permanent impairment, so he did develop, or his injury resulted in permanent restrictions, and he was assessed for a non-economic loss award, and he was awarded a 28% non-economic loss award, which is pretty significant, and that was for his organic impairment. He went on to develop psychological difficulties as a result of constant pain and trying so many different treatment modalities to deal with the pain, and nothing seemed to work. And the WSIB ended up awarding psychotraumatic disability in the claim. He was assessed for that psychotraumatic disability and was awarded a 30% non-economic loss award. So making the two awards combined 30% or 50%. He did have a major pre-existing condition, and the employer was awarded 90% SIEF to the employer to help with the accident cost statement. Doesn't really factor into this particular claim or what I'm going to be talking about. In 2008, the claims adjudicator granted full LOE to age 65, which was very appropriate considering the high level of impairment. But then he got a prescription from his doctor for medical marijuana, and the WSIB denied his request. Go figure. So he ends up at the tribunal. And this is where tribunal jurisprudence is very evident in how this particular vice chair handled this appeal. So I'm going to put this up on the screen, and I'm going to read a little bit from the decision. So in this decision, the vice chair noted other tribunal decisions that dealt with this particular issue. And he basically states, tribunal jurisprudence has set out various requirements to determine entitlement, which have been applied by successive panels and vice chairs. See, for example, decision numbers 2241/18, 667/18, 3008/16, and 2445/15. These are just some of the decisions that have been previously made that make up jurisprudence that this vice chair referenced. And so in response to some concerns that the scientific data supporting the efficacy of medical marijuana, my goodness, I can't pronounce that word, for pain relief is inconclusive. And in light of concerns that marijuana is often used as a recreational substance and can be addictive, the tribunal has developed and applied the following 6 requirements to support reimbursement for the use of medical marijuana. And these are the criteria. The worker's pain should be constant and debilitating, which was the case here with this worker. Before entitlement to reimbursement for medical marijuana, it is authorized. There should be evidence that other methods of assisting the worker to deal with his or her pain have been shown to be ineffective, which is the case here. There must also be reliable medical evidence that the worker's treating physicians have formed a reasonable opinion that medical marijuana has been effective in assisting the particular worker in dealing with this or her compensable impairment, such as the case here. In a number of cases, the effectiveness of medical marijuana has been demonstrated by the elimination or reduction of the worker's use of narcotic medications, which is a good thing. And there should be a lack of contraindications regarding the use of marijuana, such as a history of overuse or abuse of marijuana, or an escalated risk of abuse or negative psychological impacts. So as you can see here, there were a number of decisions that this vice chair used and relied on. He also referenced the criteria that had been established by the tribunal based on jurisprudence on how they deal with these types of cases. So next, I'm going to put it up here on the screen, and I'm going to read to you the vice chair conclusion in this appeal and the decision that was made. So here we go. I find that the worker's medical history indicates that he has tried a large number of treatments to help him with his pain, which have not been successful. These included various non-pharmaceutical, physical, and exercise therapies. He has also tried many prescription drugs, including anti-inflammatories, narcotics, anticonvulsants for pain control, not seizure relief, neuropathic agents, antidepressants for both mood disorders, depression, and pain relief, and most have not been successful in controlling his pain. So you can see here, he basically tried everything and anything under the sun. The worker's treatment has also been complicated by a post-accident diagnosis of bipolar disorder, which Dr. Giles described as resulting in poor resiliency in dealing with his accident-related issues of chronic pain and reactive depression. And very interestingly, he says, I also find that there is reliable medical evidence that various of the worker's treating physicians have concluded that medical marijuana has assisted the worker in dealing with his compensable impairments. Dr. Nevin wrote the following about the worker's prescription for medical marijuana on July 29, 2015. And he states, I prescribed marijuana for chronic pain from 2002 work injury. Multiple analgesics have been prescribed to the worker by other doctors previously. They provided minimal improvement for him. They are no longer appropriate since they were most ineffective. So as you can see here, friends, the WSIB had all of this information at their disposal. The recommendations from doctors and specialists, the treatments that he has undergone. He has basically cooperated with everything that was recommended. Just tons and tons of evidence in his claim file that was both considered or reviewed. I'm not going to say considered because it wasn't, by the case manager and the Workplace Safety and Insurance Board's appeals resolution officer. Friends, you've heard me say this oftentimes in this channel. I have zero confidence in the Workplace Safety and Insurance Appeals Tribunal's decision-making process. Zero. I have been doing this for 30 years, and I have tons and tons and tons of decisions and examples that I can pick from where these people just totally disregard evidence and make the most asinine, out of touch with reality decisions. It's disgusting how they do this. And the case of this gentleman, he had to go all the way to the appeals tribunal for them to consider all of that evidence that the WSIB had and finally award him the reimbursement for the treatment that he had. It's disgusting. It really is. Anyway, so friends, as you can see, there is a stark contrast between how the Workplace Safety and Insurance Board makes decisions and the Workplace Safety and Insurance Appeals Tribunal. And the most significant resource that you could ever rely on is tribunal jurisprudence. When you're looking at addressing an issue that was denied, or you're looking at addressing it for the first time, being able to have tribunal jurisprudence to support your argument the benefits are just immeasurable. So coming up tomorrow, I'm going to be talking about, this is the third installment coming tomorrow. I'm going to be talking about FEL retroactive benefits that affect retirement benefits. And so this is a very hot topic because I have seen many issues where a decision is overturned by the tribunal on a particular case, and the WSIB has to go back and re-adjudicate that case based on the entitlement that was granted by the tribunal. And in a lot of instances, they just don't get it. The worker gets screwed all over again if he or she doesn't know better or has somebody who can actually do it for them. So coming up tomorrow, once again, fellow retroactive benefits and how they affect your retirement benefits. My friends, I invite you to become a subscriber to my channel if you're not already subscribed. And for those of you who are subscribers, I thank you. I thank you for sharing my videos. I get to see how much of an impact that is having, and I really appreciate that. To become a subscriber, you just click the button. It's free. Nobody's going to come looking for money, but you get notified every time that I come out with a new video, and that's a plus. And I also ask that you share those videos. There's thousands of injured workers throughout this province who need help, and a lot of them don't know where to get it or how they can access that help at an affordable level. My company, WSIBsettlements.com, has a couple of membership packages that I specifically designed and I put together using 30 years of experience in dealing with the WSIB at all levels. I specifically tailored some of our tools to make things really simple for the average person to address issues in their claims and to manage their claims and to get success. So I also invite you to visit my website, WSIBsettlements.com, and see if there's something for you that you think could be of benefit. And as always, friends, take care now.